Today I want to talk a little bit about really the nuts and bolts of what we're all here for, and that is how to actually file for intellectual property protection. And I'm going to use the example of a patent since it's the most relevant thing to material science students and engineering students. But there are registration processes that are even simpler than this for trademarks and copyrights. And it's all sort of follows the same kind of format. You know, it's all done nowadays online with the Office of the United States Patent and Trademark Office, or in the case of copyrights with the United States Copyright Office. But I'll take you through how to file a patent application so that when you walk out of here, you'll have a general understanding at least of what you need to do. It all starts with the America Invents Act. Now, in the United States, historically, and I'm talking about going back to 1790, we were a first to invent country. What does that mean? The person that owns the intellectual property is the person who was first to invent it. And for many, many, many years, up through 2013, the way you would prove that you own an invention is by notebooks and publications and other indicia of when you began working on something. It was very difficult in many cases to prove that you were the inventor, especially if you didn't keep careful notes, if you didn't have a good record of your research and of your invention. And we were different than practically the whole world. In fact, it wasn't until the America Invents Act that the United States finally kind of joined the rest of the world as being a first to file country. So no longer is it the first to invent that gets you the intellectual property rights. It's the first to file, okay, for intellectual property protection. And this came as a result of the America Invents Act that was passed in 2013. You know, there are pros and cons to first to invent and first to file. You know, oftentimes you could conceive of an invention before another party, and if you failed to file before they did, you would still have the right to the intellectual property under the old system. Nowadays, if you're not the first to the patent office, you don't get intellectual property protection. And that's the way the rest of the world has been running things, and we finally joined the rest of the world in 2012. And the main reason why we didn't join the rest of the world before then had to do with the amount of research that goes on here in the United States in our universities. We are the hub of scientific research and development, and because universities have a desire to get that knowledge out there as quickly as possible in the form of publishing, okay, they didn't want to have an intellectual property system that disadvantaged the sharing of knowledge, that punished or penalized someone for their dissemination of knowledge. But of course, it's always a balancing thing, and with the rest of the world being a first to file, the United States, for commercial reasons, had to join the rest of the world in being first to file. First to file, though, doesn't mean first to file, which I suppose follows the usual maxim, that is, it depends when it comes to law. And the reason why first to file doesn't mean first to file is because Congress retained the grace period that we talked about last time for inventors. So if you publish something concerning an invention, you have 1 year within which to file a patent application in order to get the intellectual property rights. In a true first to file country, if you had published before you filed the patent application, you would not be able to have the intellectual property rights. Any pre-publication, any disclosure before the patent application is made in a true first-to-file jurisdiction disqualifies you, okay? But again, because of the need for universities and inventors and researchers to be able to publish as soon as the research is available and not have to keep it secret and therefore not disseminate the knowledge, Congress retained the 1-year grace period. And that really was for MIT and for Stanford and for Harvard and for all the great research universities in this country. So just as before we talked about absolute novelty and relative novelty, we're really a relative first-to-file country, not an absolute first-to-file country. Most of Europe is absolute first-to-file, okay? So we haven't joined them entirely. And that has implications for anyone that wants to market an invention or seek intellectual property protection in absolute first-to-file jurisdictions. Okay? So this slide is exactly what I just said. The 1-year grace period for application filing after an enabling public disclosure is retained here in the United States, but that may very well result in your loss of any right to intellectual property protection in an absolute or true first-to-file jurisdiction. Well, let me give you an example to illustrate this, and this is where your participation comes in. Consider the example of Inventor and Company A, who conceives of an invention in May of 2019, works diligently to reduce it to practice, and files an application for the corresponding patent in August of that same year. Okay? And suppose at the same time Inventor and Company B independently conceives of the same invention in June of 2019 and files a patent application 1 month later in July of that year. Who gets the patent? Assuming we're a first-to-file jurisdiction, who gets the patent? Come on. Yeah. B. Yes, B. You were going to say B. That's right, provided, okay? In a first-to-invent country, A gets the patent. In a first-to-file, B gets the patent. But under the AIA, it does get a little bit more complicated. What if Company A doesn't make any disclosures before the August filing? Okay, so August filing is the first disclosure. Then Company B gets the patent by virtue of its earlier disclosure, earlier filing date. If A had disclosed something before B filed the application, then A gets the patent because A gets that grace period. So this is where first to file doesn't really mean first to file. And this is where the race to the steps of the USPTO doesn't necessarily go to the swiftest. If you have conceived of an invention and you publish it before your competitor does, even if your competitor goes to the USPTO and files an application, you get the patent rights to it because you would be the one who had published first, as long as you file within that 1-year grace period. So let's say you publish a description for a better mousetrap, and you file your patent application, and you find out that somebody has already filed an application, but that they hadn't published. What do? What you would do is you would file with the USPTO an application for cancellation of the other party's patent application. And the reason would be that you had had a public disclosure prior to their filing. And in this country, a relative first-to-file country, you would win. If you go to England, or if you go to France, or you go to Spain, or you go to China, you would lose, okay? So there's a slight difference in the way these things work. It's a little bit more complicated in this jurisdiction. And it's just something that you need to be aware of. Yeah?
With public disclosure, which is the date that we are referring to? The submission paper or the actual publication date? Because usually the children can also be 1 year.
The answer is to be safe, the submission date. Because publication doesn't just mean publication in a peer-reviewed journal or some scientific journal. Publication, as we talked about in the last class, can be, talking to somebody at a bar about it, okay? So it depends on, it can be offering it for sale to someone. It can be trying to get financing from a bank or a venture capital group. So, publication isn't necessarily publication in the sense of, it's published in a journal. As soon as it's disclosed by you in some public way, that's publication, okay? So my guess would be that the submission date would be, in order to be cautious, would be the date on which at least I would use for the clock starting to tick. Now, you may be lucky in that nobody, files within that period of time, but assuming that somebody files before you file, that publication date can be important, So, who benefits? The merits of the first-to-file system have been debated. They've been debated in Congress. They've been debated in the courts. They've been debated by universities. And many argue that a first-to-file system would favor large companies. Think of IBM with, 9,000 patents, 9,100 patents in 2019 alone. That kind of those kinds of resources are an inherent advantage. But like we also talked about last time, small companies and small groups and patent paper groups or consortiums, not patent paper, but patent groups, where a group of inventors, small groups get together and share information, they can be more agile and they can have more access to what's important on the market. They can be, in many ways, a lot quicker than a big company like IBM or Microsoft or Apple or one of those giants. So my view is that this really favors the small inventor, someone who has the agility and who doesn't suffer from an enormous bureaucracy in order to bring an idea to fruition. The downside of pre-filing disclosures, very important downside that wasn't changed by the AIA. They can eliminate the ability to obtain rights in many international jurisdictions. So that grace period is only useful here in the United States and in Canada and South America. If you're looking for international intellectual property protection, the disclosure is a problem. So if you come to my office, what advice am I going to give you? Here's the question. Steve, should I file a patent application or should I disclose? What advice am I going to give you every single time? File. File. Protect yourself. File. And the cool part is that filing is really easy. It's not like the old days. Prior to the AIA, you had to file what was considered a very complicated application, and it's a very expensive process. You talked about how it takes a year sometimes to get a paper reviewed and published. Well, sometimes it takes even longer than that to develop a prototype and get the illustrations, hire someone to write the claims and the specifications. A patent application can be a very expensive and lengthy process. And, it's a little unfair to expect you to have to be able to do all that in order to protect your intellectual property. So what Congress came up with, and it's really a great vehicle, is the provisional patent application. Silence can be costly, I guess, is the lesson under the first to file jurisdiction. So, how to file a provisional patent provisional patent application. So what is a provisional patent application? So since 1995, USPTO has offered inventors a really simple, streamlined way of seeking intellectual property protection for utility patents, okay? It's the first, and it's a really great cost-effective patent filing method, and it gave the United States applicants parity with the rest of the world. So now, since the rest of the world is a first-to-file jurisdiction, there's really no excuse for you to file, for not filing a provisional patent application, since, as we're going to see, it's such a simple process. All right. So a provisional patent application is a type of interim utility patent filed with the USPTO, and it provides that a non-provisional patent can be filed, and in fact must be filed within 1 year, or your provisional patent rights will be lost. You can say your invention is patent pending from the date that you file your provisional patent application. So that gives you your protection, okay? But if you don't convert it to a non-provisional application in a year, like Cinderella, when the clock strikes midnight on the 365th day, your intellectual property rights are gone, and it goes into the public domain. Why? Because of the publication, okay? So you snooze, you lose when it comes to provisional patent rights. So you have to be mindful of the 1 year limitation. A provisional patent application gives you 1 year. After that, you have to file a non-provisional. The USPTO created provisional patent applications as a means to establish an early effective filing date, and that's for other jurisdictions. So when you file your application for a patent in France, you would refer to the provisional patent filing date here in the United States. So if you file a provisional patent application today, here, what is it, February 21st, 2020, you have that whole year to file a patent application in France. In fact, you have longer if you want, if you convert it to a non-provisional. You can file it any time you want in France and refer back to February 21st, 2020, okay? When you file your provisional patent application, that's your foot in the door. That's where your rights are saved, both here in a relative first-to-file jurisdiction and in absolute first-to-file jurisdictions. There are no official forms. I mean, talk about easy. Parts of the application, need to be written by you or a professional. You'll need to accompany the application with a cover sheet and a free transmission form. Yes. Shoot. I'm sorry. I didn't see the hands. Shoot.
Why would you file a patent in one country versus another?
Well, it depends on whether or not you want to market it. The only reason, of course, to file a patent application in another country is if your market analysis has disclosed to you that there is a market for this in other countries. Nowadays with the world shrinking as much as it is, that's more and more the case. I mean, there are 1.3 billion consumers in China for your mousetrap, in the old days, it really wasn't something that inventors had to worry about, but nowadays it really is, because these things are commercially exploited internationally. Yes. Who was it?
So going off of that, are there any, so you talk about these patent agreements, like what kind of reciprocity is there between countries? So if I found the U.S., is it valid in other jurisdictions, or do I have to always file separately?
You have to file in that jurisdiction. Your patent here in the United States does not guarantee you protection in another jurisdiction. However, you can get that protection very easily once you've obtained patent rights here in the United States. I mean, it literally is a matter of filing the forms online. It's not a complicated process. There are all kinds of conventions and agreements between countries that govern sort of reciprocity. And the rules I'm talking about now are the rules that we have to follow in this country because of the difference between our laws and theirs. So, Congress created this provisional patent application specifically because we wanted to have a seamless transition, and I guess you'd call it reciprocity with other jurisdictions. But to get that reciprocity, we had to show them that there's been a provisional filing. Yes?
What happens if you file a patent in the United States about something that's already been patented in one of those other countries, though? Or it's very similar?
Well, it would be part of the prior art, usually, and you probably wouldn't get the IP. It depends on the differences. Just because a mousetrap invention is written in French does not mean that you can file it separately here in this country. Patents are universal or international.
So the USPTO is examining databases from all countries in the world when they're looking at it?
Yeah. And it's very rare these days for a patent not to have international protections. Think of drugs or Tesla. When they owned that technology, it was registered everywhere in the world. So, if it's not registered, then it's a much more cumbersome sort of infringement action that you have to undertake. But it's still first to file is who owns the technology. And whether it's in France or the United States, first to file wins the day. There needs to be basically these three things. The specification or description of the invention, okay? The figures or simple drawings that show what your invention looks like and hopefully what it does. And then the transmittal or cover letter, which gives the names of the inventors and who's filing the application and certifies that there are no government funds that were used. But you couldn't get any simpler than this. You literally can scratch this out on a piece of paper, okay? And so long as you use the USPTO transmittal cover sheet, you're good to go. I mean, literally all you need is a typewriter or a computer or something to write it down, a simple illustration, and the $140 that it costs to file it. And the filing fees are actually a sliding scale. There's actually a provision in the patent for micro entities, for small entities, and for large entities. If you're a micro entity, that means, in other words, a single inventor, the patent fee, I think, is $148. I'm not sure. If you're slightly larger, maybe a group of 3 or 4, it could be $240. It also depends on how many claims. But the point is that you can put it on your Visa card. And in fact, you put your number down on the transmittal sheet that you file electronically, and the USPTO reads your application and decides what the fee is, and they charge your card. That's literally how easy it is. I don't know if any of you do road races or sign up for different classes. But you go online, you put your name, address, phone number, or whatever, your email address, and your Visa card number, and you're registered. If you add a specification and drawings, you get a provisional patent application. That's how easy it is. So let me talk about the other things that in more detail. So a provisional patent application does not need to have claims or formal drawings. All right. This is one reason why it's much less expensive. And when I talk about formal drawings, I mean going to a graphic artist and hiring someone who does mechanical illustrations. There are people out there that do this. That can cost hundreds, thousands of dollars, okay? That's not necessary for a provisional patent application. It is necessary for a non-provisional application. But if you just want to get your foot in the door, if you want to do something fast and dirty, you can literally sketch it out yourself, or there are computer programs that help you draw and illustrate things that are really cheap, can be really cheaply done, all right? So no really formal mechanical drawings are necessary, and you don't need claims, okay? I'm going to take that back as soon as I've said it, because while the USPTO does not require you to have claims, my advice is to always file at least one claim in order for your provisional patent to have any meaning or utility. You know, later on when you convert this to a non-provisional application, first of all, it makes the non-provisional easier to file. But if you ever had to defend your provisional patent application, understanding what your provisional patent was intended to cover would be very difficult if you didn't write a description about what it does. So while the USPTO doesn't require a claim to be written or claims to be written any more than it requires formal drawings, my advice is to file at least one claim when you file your provisional. And we'll go into claims, you'll see how easy it is to do. Of course, the more complicated the technology, the more complicated and difficult it is to write the claims, but I have some easy illustrations for you. So here's the specification section of the application. I'm sorry for the density of this slide, but this literally is everything that needs to be included on the specification sheet, and we'll go to it. I've got it queued up here, but it's a form at the USPTO. But this is what it includes. The title of the invention, okay, mousetrap, identities of the inventor or inventors, a background of the invention, which is simply a description of the technology area of the invention. And we'll go into examples of that. What the problems are that the invention is designed to address, okay? A brief summary of the invention, describe its unique features or what it looks like. A brief description of figures or drawings. Usually when you include a drawing, you should include a description of the drawing, what the drawing is of. And we'll go through some examples of it. A detailed description of the invention, in which case you actually describe exactly what the invention is. In a provisional patent application, you need this. And a claim section, and while it's not required, it's good practice, as I said. It gives the examiner an idea of what your invention is about, and later on, if it gets challenged, you can go back to it and say, here it is, this is what I said my invention would do, and this is the type of protection I'm entitled to. And finally, an abstract section, which is just a general description. And we'll go through each one. So, but before I do, I want to talk a little bit about claims, because claims are so important to non-provisional applications. And my advice to people is to do a claim or more than one claim in a provisional application, because it makes your job much easier later on. Remember, if you're filing the provisional application to get your foot in the door, your intention is probably to file a non-provisional later on. So the more work you can do up front, you know, the easier it will be converting your provisional patent application to a non-provisional application when that one-year deadline expires. You'll find oftentimes as an inventor, you get busy developing prototypes, trying to get money. The next thing you know, 11 and a half months have gone by and you don't have your non-provisional application ready. So if you can get some of the work done up front, I think it's always a good idea. And so one thing about a non-provisional application is, even though a claim isn't required, I think you should include a claim. And again, this is not rocket science. How do you determine what a claim is in an application? What does the patent examiner do in order to determine where the claim is in your application? He looks for the words, or she looks for the words, I claim that, or what I claim my invention is blank. That's it. You know, like I said, not rocket science. So I have some, another thing is multiple claims. Oftentimes your invention will solve more than one problem. Who was it? Maybe they're not here today, but it was Somebody last week talked about the ceiling fan, okay? There's a ceiling fan that circulates the air, but the other thing, it did some other things, like it was made of fluorescent materials, so it was decorative, it maybe illuminated the room. So for a decorative ceiling fan, you can have more than one claim. My claim is that my ceiling fan efficiently moves air around in a room. Secondarily, it provides illumination. Third and subclaim or dependent claim would be that it looks pretty, that it's decorative. So those are examples of dependent claims or multiple claims in the same patent application. And again, you don't have to have them in a provisional, but if they're obvious to you, you include them, because the claim is what defines what gets protected. So when it comes to intellectual property, when you want to define what you own, you go to the claims. That's how you do it. And remember how we talked about, you know, they have to be proven in their utility. So not only do you have to claim what it does, but it has to actually do it. But claim you must. You must describe the claim so that we know the limits of what your intellectual property protection is, okay? Now let's say with the ceiling fan you forgot to include, you know, a claim about it having tremendous health benefits. It's kind of like the opposite of what wind farms or some people think wind farms do. Okay, let's say your ceiling fan actually has tremendous health benefits, but you don't include that in the claims. Later on, when somebody files a ceiling fan application that's meant for therapeutic purposes, and you try to cancel that application, you'll find you'll have a very difficult time because you didn't claim that advantage, that therapeutic purpose in one of your claims. So you want to cover all the things that your ceiling fan does. Yes?
So if they dispute one of the claims in the patent, does that mean the whole patent application is thrown out?
No. What it means, as Stanford found out, is that if you make multiple claims, if there are claims that you can't prove, then those are the ones that get thrown out, but the others are left intact.
So it incentivizes you to just go nuts, basically.
Well, you know, the problem with that is that you have a claims examiner that's going to say, okay, show me your evidence. So it is an art. You want to describe the claim in broad enough terms that you can squeak by, but you don't want to be writing something that you can't prove. It has to pass the straight face test, I guess, would be the best way of describing it. Of course, it depends on a case-by-case basis, but when if you're writing a gene editing series of claims, you want to do it as broadly as possible. You're hopefully going to get it past the claims examiner, but you should know that if you get a good claims examiner, they're going to make you prove. They're going to say, hey, how does this work in human beings? And you'll say, oh, gee, well, I've never really actually proven it in that, and all the attempts that we've made to prove it, that it works in human beings have failed. So the examiner is going to say what? Rejection, at least as to that claim. So they're going to say, you need to scale back your claims. You need to limit your claims to what your research proves you can do. And that's the art and the science of claim writing. In claims, every word is important. Again, whether you're talking about a gene editing methodology or you're talking about a device, you've got to be as descriptive and precise. And you will be the best source for what works here. Nobody knows as much about your research and your invention as you do. And so this is where the inventor really comes in handy. If I'm the lawyer that's been hired by the inventor to write a claim, I'm going to really want to sit down and understand everything I can that inventor understands before I sit down and write those claims. You're going to be the ones that are best place to say what your invention is and what it can do. And of course, the fee submitted with the non-provisional often depends on the number of claims. Okay, so let's see if you can guess what this is. This is a claim. I've taken some everyday things that are actually in the public domain. Okay, I'll give you a hint. But this is for illustrative purposes. Let's see if you can guess what it is. But this is a typical claim for an everyday device. I claim a self-propelled vehicle comprising a body carriage having rotatable wheels mounted thereunder for enabling said body carriage to roll along a surface. B, an engine mounted in said carriage for producing rotational energy. C, means for controllability, coupling rotational energy from said engine to at least one of said wheels, whereby said carriage can be self-propelled along said surface. What does this claim describe? A car, yeah. Okay. But this is an example of a claim section, a claim for a simple everyday device. Hopefully it gives you an idea. This is a different one. A method for joining two pieces of cloth together at their edges, comprising the steps of A, providing said two pieces of cloth and positioning them together so that an edge portion of one piece overlaps an adjacent edge portion of the other piece, passing a thread repeatedly through and along the length of the overlapping portions in sequentially opposite directions and through sequentially spaced holes in said overlapping adjacent portions, whereby said two pieces of cloth will be attached along said edge portion. Can anybody guess what this is a claim for, or would be a claim for?
Sewing.
Yes, sewing. By the way, excuse me?
If you want to sew something now, you need to pay the rights to the person.
Well, again, this is for illustration purposes. I thought if I chose some things that would be familiar to everyone, but, you know, picture the looms that built Lowell and New Bedford and Worcester and Springfield, all the machines. You know, this example is not far off from a description of how those machines would work. And if you were, Henry Ford, and it was 1890, and no one had ever had a car before, although the first car was, in France, right? Wasn't it Peugeot or somebody who, I don't know who invented the first automobile. But of course, if they were filing an application for it, that first one would be a pretty good example. These things happen to be, in the public domain now. Here's something from material science students. I claim a rigid building and paving material comprising a mixture of sand and stones and a hardened cement binder filling the interstices between and adhering to sand and stones, whereby a hardened, rigid, and strong matrix for building and paving will be provided. Anybody have any idea what this could be for? Concrete, exactly. But that describes it. The reason I put these up here is, a lot of this is requires writing down what you know about an invention, really in formalistic ways. A lot of what, in the way we describe things to one another is intuitive, but when it comes to the Patent and Trademark Office, you've got to be explicit, and every word counts. How about if I claimed a method for joining two pieces of bread together, and on one side of one piece of bread, you would spread a 1/4 inch layer of peanut butter, and on the other piece of bread, you would spread a 1/4 inch layer of jelly. And thereafter join the two pieces of bread together and have the jelly and the peanut butter interface. What is that a description of? It's a peanut butter and jelly sandwich. not like anyone has ever described it before, but that's the sort of formality that is required when you write a claim section. I need you just to get you thinking like that. So, all right, other than a claim section, you need an abstract. Abstract is really pretty simple. It's a short technical summary of your invention that includes a statement of the use of the invention. It is primarily used for searching purposes. So the abstract is important because it goes into the database at the USPTO and it becomes part of the prior art. So when anybody does research trying to determine whether or not their invention creates daylight between the prior art and it, this is the information that's contained in the USPTO database that would come up in the search. So the abstract is very important. And it would start with things like, the upper portion of a running shoe comprised of ... So then it would go right into the category in the USPTO of running shoes. The purpose of the abstract is to enable the USPTO and the public to determine quickly the nature of the technical disclosures of your invention, and it points out what is new in the art to which your invention pertains. It should be in a narrative form and generally limited to a single paragraph. When it comes to the provisional application, it has to be on a separate page, and it should be no longer than 150 words, but usually you can do it in a lot less. Here's an abstract for a mousetrap. I've used this example in class a bunch of times, but to give you an example of, this is, by the way, an actual abstract from the USPTO for a patent that issued on a mousetrap. And it's described as a disposable trap comprising odorless rubberized glue or like sticky surface for capturing a mouse or like pest. A cover over the surface which has provisions for at least one opening therein for allowing the mouse to enter is disclosed, wherein a window or like is provided for allowing the user to inspect the interior to see if a mouse is trapped therein, and wherein externally activated internal bait means are provided, which bait is stored in an enclosure, is in a sealed condition, but which may be exposed within the covered trap by manipulating an external activator such as a push-up pedestal, which is pushed up to break a membrane within the trap and expose a change of bait material. I mean, you can actually sort of picture or reverse engineer, what this thing looks like from this description. And obviously, it is set apart from many other mousetraps that I'm familiar with, okay? I keep thinking of one of those oven bags that they used to cook chicken in when I think of this thing. But it's, it's a departure on a mousetrap. So it's a sticky surface that you can look into to see if you've got your pest. One time I was staying at a really bad hotel in New York, and, I was packing my bag and something fell out and rolled under the bed. And I made the mistake of getting down on my hands and knees and reaching under the bed to try to find this, probably was a nickel or something. I don't remember what it was. And I came out with this thing here on my hand. So just a little free advice. Don't reach under a hotel bedroom, a bed in a hotel without looking there first. We talked about the illuminating fan blade. Here's the abstract for it. A fan or other rotating device is illuminated using light projected from LEDs mounted in a circle about the axis. The light colors may be the same or different, and the device may be used for basic illumination or decorative effect. Really pretty simple. So when it comes to drawings, figures, and illustrations, like I said, you don't have to have formal drawings, but you do have to include some drawing with your provisional. At least I think you should. And it really, a picture is worth 1,000 words. Drawings, figures, illustrations not only show what your invention looks like, but often can show how it works. Picture the mousetrap. You can imagine a series of illustrations where you have the trap, then you have the trap baited, and then you have the mouse walking into the trap, and then you have a fourth illustration showing what your mousetrap does. It not only shows what it looks like, how it operates, but also what it's supposed to do. So therefore, drawings, figures, illustrations can take the place of detailed specifications and claims in a provisional, and they are really essential to any patent application. Again, trying to figure out the limits of your patent protection, they're going to go to the illustrations. Okay? If those illustrations show something that's being challenged by somebody else, you'll get credit for it because you're able to show it in your illustration. And I brought some examples of illustrations from a provisional patent application. Again, not real sophisticated stuff. You know, I bet you anybody in this class can do this on their computer at home. Very, very simple stuff. These are spiky balls. My friend Alex, Professor Alex Slocum, did these. He came up with the idea when he was coming back from Australia after having done an Ironman race, and his feet were sore. And he thought, gee, wouldn't it be great if I had something that I could put underneath my feet and use on the airplane? And that's how he came up with the idea. Anybody ever visit that site called Passenger Shaming? You know, so there's a great site, you should go on it. It's called Passenger Shaming. It has all the outrageous things that people do on airplanes. And you know, there's a whole thing now where they're trying to get airlines to have, as part of their pre-flight videos, basically an airline etiquette video that tells you, don't take your pants off on an airplane. Don't dry your hands using the fan above the, I mean, don't change a baby on the tray table. But you know, people actually need to be told these things, unfortunately, these days. Well, I'm not sure whether this would be banned by passenger etiquette standards these days, but that's how he came up with the application. And these are just some illustrations of what he included in his application in order to show how it works and how it was made. And there's a detail of a cutaway. It shows the string that goes through it and how the ball is hollow. Pretty simple stuff. This is the spiky ball foot abstract, foot massage abstract, and there's the description. An adjustable foot massaging roller device for massaging various surfaces of the feet for general health and comfort of the user, as well as to provide relief for specific conditions such as plantar fasciitis. The device consists of yada, yada, yada. I brought these in to show you. This is another invention of Alex's. And this goes back to how provisional patent applications are really a good idea for inventors, because you will often find that the original inspiration for your device develops over time. It evolves. It gets more sophisticated. These are sort of a rudimentary, I mean, you can even, there's a nut and a bolt holding, I believe this is, I'm trying to remember what he told me it was. It's not a dog dish, but something like that. This is a pair of flippers or swim fins that have been cut off. But for people designing, like you, inventors who are coming up with a prototype, this is an example of, the first kind of go through on one of these things. I'll show you this is the Ultra, or the Aqua Runner's drawing that actually was submitted with the application. But this was the first start. And, Alex was trying to come up with an idea for rehabilitation of people with running injuries. So you put these on and then you go run in the pool with them. The idea was to create resistance. And I'm sure at this point in the class, everybody could write an abstract for those right now. And then, you take pictures of it or you do illustrations of it and you get your provisional patent application. Later on, when you file your non-provisional application, it'll look more like this when you hire somebody who knows what they're doing to do an illustration for you. Again, this was patented by Alex, one of his, 200 patents or 300 patents. But it's a really simple device, and I thought it would be a good idea for you to have a look at one to show you that These things are not as daunting and as complex and as difficult as you may imagine them to be. If you can think of it and if you can express it in tangible forms, you can get intellectual property protection for it as long as you've got $148. It's really simple stuff. So that's it for today. Next week, I think I'm going to have a guest lecturer come in I think next Friday. We're going to do a lecture on the pitfalls and traps for the unwary when it comes to inventors and researchers and scientists. Mike McGurk is a terrific lawyer. He used to work at one of these giant engulf and devour firms. He used to be a claims examiner in the USPTO, so he has some great stories. And I think that they'll be illustrative of the things that, you know, the way to get good at anything is to learn by other people's mistakes. At least that's how I learn. I make a lot of mistakes, but not the same one twice. So we'll bring in some examples of mistakes that people have made so that you can avoid the certain pitfalls for inventors and researchers out there, and hopefully take some lessons away from them. Thanks for coming today. I'll see you on Tuesday.